Justice Barrett.
Counsel, would the government be amenable to having defense counsel insert qualifications on the right to appeal and bargaining for the kinds of exceptions that some of the courts of appeals currently allow?
Yes, I'm very glad you raised that point. Defendants are always free to do that. I mean, again, I want to be clear. It's a very important term to us. So in some cases, we won't budge. And in many cases, we won't budge. But it's case by case. It's district by district. And we do enter into plea agreements with carve-outs for constitutional claims, carve-outs that limit the appeal waiver to only certain guidelines ranges, all the rest. And we have, in the appropriate cases, entered into plea agreements with no sentencing appeal waiver at all. So it really is a matter of defendant choice here.
So you've emphasized that if we're going to do something other than the contract analogy, we have to find some source of law in which to ground it, and you've been pressed about supervisory power. I'm wondering whether, in addition to supervisory power, another rationale is that this isn't a pure contract agreement because it has to be accepted by a third party. The district judge has a role in the process. And hence, because the district judge has a role in the process, there have to be some parameters to what the district court does in that process. And so our supervisory power over, it's not just purely between the government and the defendant. So our supervisory power over the third party in that process is a source of law that can justify some of these exceptions.
I see that argument. I think that could make some sense. I mean, I want to be clear, it's often the same judge that approves the plea deal as the one who sentences. It's not necessarily, but if you're just sort of saying the district court, not specific judge, I see that point. And if that's how this court wants to ground a series of exceptions, I think that makes sense. I want to be clear. We have gone sort of hard on the contract doctrine here because that's how petitioner briefed this case, but I'm not trying to suggest that this court lacks powers.
But you would prefer, I guess I'm still a little bit confused when I asked you that before, like, are you only talking about it in terms of contract because the petitioner did? You said no, you do think of it as a contract?
Because there's no constitutional right to appeal and because petitioner hasn't briefed it as a supervisory power or on this theory that you've suggested, we do think the most logical place would be if the avenue that you've suggested is the power to supervise the accepting of the plea. I mean, I think that could make some sense as an avenue to accept these carve-outs.
Okay, thanks.